Welcome, students. We're going to talk about my most favorite section of notes and the last section of notes in this unit, civil liberties and civil rights. This first section of notes will be on civil liberties. The next section of notes will be on civil rights. Let's look at civil liberties, America's commitment to individual freedoms, civil liberties. So what's the difference between civil liberties and civil rights? You should know these two definitions here. Well, first off, civil liberties are protections of citizens from unwarranted government action. Civil rights are the government's responsibility to protect citizens. So a civil liberty is protection against the government. Civil rights are protection against other citizens. The Bill of Rights emphasizes on the limiting the powers of the national government, makes it arguably more of a Bill of Liberties versus a Bill of Rights. So the Founding Fathers were more focused on civil liberties versus civil rights. That's why conservatives focus more on civil liberties versus liberals and progressives that focus more on civil rights. And you'll see that with different legislation. When it comes to the First Amendment, individuals that are more progressive focus more on the civil rights of the First Amendment, whereas conservatives will focus more on the civil liberties there. So, selective incorporation. Bill of Rights has been gradually applied to the states. So the Bill of Rights originally only dealt with the federal government and restrictions on the federal government. However, the states have also been restricted and what the government of the states can do to the individuals. Get Low versus New York was the first case. Free speech to be incorporated applied to the states. Basis is the 14th Amendment. The 14th Amendment really changed things when it came to the states. After the Civil War, the federal government became more encroaching on the states. Due process clause gives a freedom or liberties, so to speak. The equal protection clause provides the rights for all, right? So the 14th Amendment, what it means to be a citizen in the United States of America, really had an overarching focus on not just the federal government with civil liberties, but also the states can infringe on civil liberties. We have some amendments that you'll need to know. You don't need to write this word for word. But the Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment, an indictment of a grand jury, nor be deprived of life, liberty, or property without due process of law. So the Fifth Amendment and also the 14th Amendment have both been selective incorporation, meaning that the states can't deprive people of certain due process or equal protection of the laws. And so the right to privacy, for example, with Roe versus Wade, had become a precedent under the 14th Amendment with a civil rights. The First Amendment's rights grants free expression, but does not protect all speech, such as libel, which is written slander, spoken, seditious speech, advocating the overthrowing of the government by force or to disrupt its lawful activities, false advertisement, fighting words, hate speech, resulting in violence. That's the key. If it doesn't result in violence, it can't be considered as fighting words or necessarily hate speech. Obscenity, according to the community standards. So when it comes to free speech, we do have free speech. However, that First Amendment free speech can be taken away if it is a freedom that is not protecting of other people's freedom. So your freedom cannot hurt somebody else's freedom. Your freedom to strike somebody is taken away once you actually do strike them, so to speak. A lot of these are vocab terms. Symbolic speech, however. Symbolic speech mostly covered, but must follow the law. So any type of symbolic speech is generally covered under freedom of speech. Texas versus Johnson, flag burning is covered by the First Amendment. And so, though it might not be the best form of free speech, it is protected if done the right way under fire code laws. So you can't just simply burn a flag inside a building with a bunch of people because the fire code and fire laws would restrain against that. However, you can do that in a peaceful way. Prior restraint. Constitution allows punishment after words are spoken or written. So if there is a speech that somebody gives and then it's proven that somebody was inspired by that speech to do something illegal, then the person who gave the speech can get in trouble. Landmark cases on this would be New York Times versus the United States. The Pentagon Papers, only exception national security. So under national security, the Pentagon Papers were ruled that they didn't threaten national security. So the New York Times actually won this suit that the United States had put on them during Richard Nixon. And so since the Pentagon Papers had not violated national security, it was seen as okay. Hazelwood School District versus Coolmere. Students may be reasonably censored. So if a student wants to demonstrate their freedom of speech, it can't distract from learning, it can't distract from culture, so they can do it in a peaceful, subtle way. For example, if you want to have a sticker on your water bottle against abortion or in favor of LGBT, you can do that. However, if you are never taking your seat and you're standing in the background to protest a cause, that becomes a distraction. And the Hazelwood School District ruled on that, the Supreme Court. Students' rights, major precedents. Tinker versus Des Moines. This was the armbands, where students still have reasonable free speech rights if they are not disruptive, as I had mentioned. So you're allowed to wear an armband as long as it isn't disruptive to the rest of the community. A few years ago, we had a female who wore a Black Lives Matter shirt, and one of the coaches asked her to remove it because of the disruption to the normal attire of the day, and so that would have been constitutionally the right thing for the administration to be able to do. New Jersey versus TLO, admin, can search students if they have reasonable suspicion, and that's the key, reasonable suspicion. That's why the use of drug dogs creates that reasonable suspicion if the drug dog senses drugs. Otherwise, they can't just simply search without that reasonable suspicion. So it could be a tip or it could be something else. Major trend, administrators have the right to limit students in order to protect the school environment. And that's really become the precedent. That if they're trying to protect this school environment, trying to keep from issues arising, then they can take away those students' rights. And so, for example, wearing a Black Lives Matter shirt at school, the administration does have that right at any school, public or private, to infringe on that student's right because of the school environment. Whether you like it or not is not the key. Whether it's constitutional is. Right to assemble and petition. First Amendment gives right to peaceably assemble. Peacefully is the key there, so rioting is not part of First Amendment. Cannot provoke others to endanger life, property, or public order. So the question is, the recent protests that we had that seemed to encourage the destruction of property was that peaceful, and I'm sure the Supreme Court will hear a ruling in the next year or so based on that. I'm sure that somebody will file suit. Violence, block a public street, is technically not allowed either, though a lot of times that protest does happen. Technically, it is illegal. Government role must be content neutral. So the government cannot pick one side or the other. Though with the Black Lives Matter protests, you did have mayors, such as in D.C., paint the street Black Lives Matter. That was not content neutral, and so technically that mayor was not allowed to do that. They can regulate assemblies on the basis of time, place, and manner, but not on what may be said. So they cannot limit or encourage the content of what is being protested. Freedom of religion, second important First Amendment clauses. Establishment clause prohibits the government from establishing a national religion. There's this wall of separation that Thomas Jefferson talked about in his famous Separation of Church and State letter. Free exercise clause guarantees to each person the right to believe whatever religion he or she chooses. And the focus there is believe. You can believe whatever you want, but you can't necessarily enact. And that came into focus in the late 1800s with the Mormon Church in Utah, that not only believed that polygamy was okay, but actually practiced polygamy, more than one wife. And so the federal government said that is illegal, even though marriage is under a state law. The federal government said that is illegal. You can believe whatever you want, but you cannot simply marry as many people as you want. What about with schools and school prayer? Engle versus Vitale was public school sponsored prayer is unconstitutional. Lee versus Wiseman, unconstitutional for clergy to pray as part of a public school graduation. So since the 90s, you cannot, at a public school, have a clergy member of any religion pray at a public school graduation. Santa Fe, this is not Santa Fe private school in San Diego. This is in New Mexico, versus Doe. Prayer over the loudspeaker at school-sponsored events is unconstitutional, even if given by a student. So a student is not allowed to pray over the loudspeaker either under that court ruling. Aid to parochial schools, Lemon versus Kurtzman, 1971. Lemon test is standard which determines whether or not parochial is religious schools, receive aid from the government. And so under this 1971 rule, parochial schools were not allowed to receive aid from the government if there was a purpose of funding must be clearly secular. For example, at Christian High, teachers are allowed to have funds for educational purposes, but if those educational purposes have any type of religion tied to them, then that is illegal funds. Its effect must not advance nor inhibit religion. So, for example, if I want to go to a religious creationist museum, and I want the federal government taxes to pay for me to go to that creation museum, that is illegal. I cannot request the taxes to go to that. 3, must avoid an excessive entanglement of government with religion. And that's the key right there, is that we don't want the government to be tied to religion, because we want to protect religion and also protect the government, keep them separate from one another. Because you have to remember that in Europe, we've had a lot of established churches that have forced people to believe, and both people that are religious don't want to be forced, and also people that are non-religious don't want to be forced. Religion precedents. Court-issued opinions. Prayer in legislatures is okay. So at the state level or the federal level, you are allowed to have prayer. Use of public facilities for religious use is okay. So if you want to use that public facility for religion, you may. Displaying religious symbols, nativity scenes are okay as long as multiple religions are represented. So you are allowed to have a nativity scene as long as you allow other religions to do the same. And that really gets to the heart of our civil liberties, is that we want to make sure that everybody has the opportunity to be represented if they wish. If only one religion decides to be represented, that's fine. Whatever religion it is, but the opportunity must be granted and allowed. Next, we have the rights of the accused, the Fourth Amendment. No unreasonable search and seizure. So we've gone from religion, now we're looking at rights of the accused. Exclusionary rule. Evidence obtained without a valid warrant may not be used in court. So under the Fourth Amendment, no unreasonable search and seizure. It's unreasonable if there is no warrant that has been used and evidence has been obtained. And so you need to make sure that you have that warrant in law enforcement. The Fifth Amendment says no self-incrimination or double jeopardy. So you cannot self-incriminate yourself. That's why they oftentimes tell you to talk to a lawyer first so that you don't basically under distress or punishment feel like you have to self-incriminate yourself because maybe you didn't do it. Maybe it was because of the stress or the supposed torture or something of that nature that you confess to something that you didn't do. Sixth Amendment, right to a speedy trial, public trial, right to an attorney, right to confront witnesses. That is under your constitutional rights as well. Eighth Amendment, no cruel and unusual punishment, no excessive bail or fines. So these four constitutional rights right here under the Bill of Rights that were added to the Constitution as the Constitution was being ratified are very important when it comes to civil liberties, to protect the individuals from the government. That is the key of civil liberty, to protect individuals from a corrosive or extreme government. As you can see right here, you have the number of executions by state using the death penalty. And so the death penalty has been a question of Eighth Amendment. Is it cruel and unusual punishment? Or is the death penalty justice? And so you can pause and look at the different death penalties there. Now, the question with death penalties is, what about exonerations? So when somebody's on death row waiting to be killed for a convicted murder that they had done, what happens if the forensic evidence or new evidence shows that they didn't commit the crime? And that's what an exoneration is. And we've had a number of exonerations that have said, you know, a total of 138 exonerations by state since 1973 that have said that these people didn't commit the crime and they shouldn't be given the death penalty. And so that makes a lot of people question the death penalty and how just it is. States without the death penalty, as you can see right here. Thank you for taking these notes.